Good evening, everyone. Thank you so much for joining us today for the last session of our Essentials of Wealth Management series. Tonight, we will be talking about estate planning. Our guest speaker tonight is Soraya Marshall White. Right, I'm so sorry. And she is a estate and elder law attorney, and she is the founder of the Autonomy Group in Rock Hill, South Carolina. And just a few housekeeping things today before we get started. So you will notice that we are in webinar mode. And so that means that you're not allowed to turn on your camera or unmute yourself unless you are raising your hand and promoted to talk. So if you have a question during our Q&A, we will go ahead and ask you to raise your hand, and that way you're able to ask your question live. But if not, you feel free to drop your questions in the chat box or the Q&A box at the end, at the bottom of your screen. And we will have a Q&A session towards the end of our presentation today. And let's see if I'm missing anything. As you can see, today's session is recorded and will be available on YouTube later this week. So you're able to view it later if you miss anything. But without further ado, I will turn it over to Soraya here and she will get started.
Thank you so very much, Kiana. I greatly appreciate the warm intro. And good evening, everyone. I'm so very excited to be here this afternoon. I'm thrilled to have the opportunity to share such important information with you, and even more excited that you've decided to join. So as Kiana mentioned, I'm Soraya Marshall Wright. I am a trust and estate attorney practicing in North and South Carolina. And my practice focuses primarily on elder law and special needs planning. So in the last couple of segments of your wealth management essentials, our wonderful PAC volunteer, Melissa, shared lots of information with you about how to not only maximize your wealth, but on how to protect your assets. So I'm hopeful that some of the basics that I'll share with you today will kind of help bridge the gap on how to put a neat bow on all of that and make sure that all of the work that you do with someone like a financial planner or other professionals who may be helping with your wealth management will be protected, and that your end goals will actually be actualized. So throughout the presentation, as I go through this information, it can be a little bit boring. It can also be a little overwhelming. I do encourage you to please jump in at any point, raise your hand, jump in the Q&A or in the chat rather, and ask questions throughout. I'll be happy to answer them as I see them. And as Kiana mentioned, of course, towards the end, we'll reserve some time for additional questions that we don't get a chance to address during the presentation. All right. So, of course, I would not be an attorney if I did not start this presentation with a legal disclaimer. Just want to let you know that any of the information that is shared with you during this presentation is intended for educational purposes only, just general information. It is not intended to be specific legal advice for you. I am licensed to practice law in North and South Carolina, so the information that I'll share will be general, but will generally apply to those two jurisdictions. If you are in any other area or if you have estate planning needs, you certainly should consult with an attorney licensed in your state. All right, so what exactly is estate planning? So estate planning, honestly, I feel like the term is a little big. Sometimes it gives the wrong impression. And people often think that if they aren't super rich or have millions or lots and lots of assets to speak of, that they don't necessarily need to do estate planning. And I hear people say all the time, well, I don't really have an estate. I only have a house, or I have a couple cars, whatever the case may be. I'm not rich. I don't have an estate to speak of. I want to kind of debunk some of that for you today in talking about estate planning generally and how all of the different pieces and documents that you can put in place will not only protect your wishes during your lifetime, but after your passing, and also help protect the wealth that you've likely worked so hard to acquire. So basic documents when we think about estate planning are those that are listed in the screen before you. And let me go back because I'm going a little too fast. And that would be a will or a trust, advance directives, powers of attorney, and also estate planning includes probate towards the end of the process. And when we really think about estate planning, I really want you to think about it less so like someone with a whole bunch of money or riches planning or creating a trust fund for someone, but more so like bringing the the future into the present so that you can do something about it right now. Through your estate plan, you're not only going to decide who makes decisions for you if you become incapacitated, but who gets your assets after you're gone. Most people have heard of a will. When people come to me, the majority of the time, the first thing that they'll ask for or they think they need is a will. You probably already know what it is, but I'll just speak generally. A will is, of course, a document that allows you to distribute your assets after your passing, but it does so much more than that some people do not consider. It appoints an executor or a personal representative to administer your estate after your passing. This is a person that you trust who's going to make sure that your wishes are actually followed. Doesn't have to be a family member, doesn't even have to be someone who's inheriting from your estate, but someone who's going to ensure that your wishes are followed. Additionally, your will is going to give certain powers to this person, the executor or personal representative, telling them exactly what they can do with your assets, how they can do it, and ultimately whether or not they need court intervention or court permission to do certain things. So in some cases, for some people, if their estate is not very complex, they may feel like a will is not needed. But some of the powers that I mentioned that is granted through a will is something that could definitely save your executor or personal representative both time and effort in having to distribute your assets to your heirs. The next part of your estate plan, which honestly I think is one of the most important, are advance healthcare directives. So advance healthcare directives can consist of a couple of documents. You can have a healthcare power of attorney that appoints an individual to make medical decisions for you. It's important to understand that even if you are, for example, a married person, or you've had conversations with your children, or you've discussed with someone you trust what you want to happen if something happens to you health-wise, without the proper documentation, it may be difficult for that person, even if they're your next of kin, to make certain decisions for you. So having advance directives in place, specifically a healthcare power of attorney, is going to authorize this person to make those decisions, even if you're not in a position where you can actually verbalize that to your doctor or to the treating hospital. Another part of your advance directive would also include a living will or a declaration for desire for natural death, as we refer to it in South Carolina. This is a document, unlike a last will and testament that says what you want to happen to your assets after your death, and that appoints the executor, as I mentioned. It is the document that would tell your healthcare professionals and your loved ones, what exactly do you want to happen if you get to a point of no return? What I mean by that is doctors have already determined at this point that you're not likely to make it. Do you want to be force-fed? Do you want to be on life support? What type of life-sustaining treatment would you like to receive or not? And that document will outline that for your loved ones so that they're not having to make such decisions at the very last minute. And a power of attorney, a durable power of attorney specifically, is a document that's going to allow individuals to make financial decisions for you. Again, a lot of people like to focus on the will, but it's important to remember that a will is only triggered after your death. So you've appointed someone who's going to make decisions, who's going to distribute your assets, who's going to ensure that your wishes are followed, but that's only after you pass away. If something happens to you and you're not able to direct someone to go to the bank, to pay your bills, to cash your checks, do your normal day-to-day, a power of attorney is going to authorize someone to be able to do exactly that. It's important, though, to know that all powers of attorneys are not created equal. And as I speak to this audience specifically, it's important to know that there are basic powers of attorneys, such as the ones that you may find at Office Depot, that's going to give someone the authority to maybe go to the bank and pay bills and sign checks. And then there are what I refer to as enhanced powers that may allow someone to make even more complex decisions for you, such as restructuring your estate plan and giving away your assets and doing other type of planning that may be important for you if you're someone with special needs and someone who may need assistance for long-term care purposes in the future. Now, I like to say that a power of attorney is essentially like giving someone a blank check. So it is very, very, very important that whoever you appoint for this role is someone that you completely trust. In most cases, the powers that are included in this document is going to allow this person to do just about anything that you could do. In some cases, even be able to change your beneficiary designations, open credit cards, give away all of your assets. So you definitely want to make sure that the person who is in this role is someone who's able to do it well and someone who would not misuse any of your assets. Last but certainly not least, big part of your estate plan could include trusts. Now, trusts are created in different flavors. But first, I'll explain that a trust is basically like creating an entity. The way I explain it to my clients sometimes, it's like basically having a treasure chest. You have the key in your hand, or maybe you don't. In this treasure chest, you decide all the assets or items that you want to put in it. And you decide if you want to hold on to the key so that you ultimately control what assets go out and what assets come in, or if you want to give the key to someone else to do that. The distinction between the two are the two different flavors of trust that I'm referring to. All trusts are either going to be revocable or irrevocable, and they each have different purposes. And depending on your wealth management goals or your long-term care goals, one or more of them may be appropriate than the other. So first, let's talk about a revocable trust. A revocable trust generally is what most people think about when they're thinking about a trust. They have a private document. They're able to transfer some of their basic assets in there, maybe their house, maybe a few bank accounts. They're able to dictate how they want these assets to be distributed to their loved ones. And ultimately, they're able to avoid probate. For the most part, when people come and they say, I want to create a trust, their biggest concern is, I want to avoid probate. Well, I don't know how things are in other states. I have heard some horror stories about states maybe like California or Florida or other states where probate can be extremely complicated, extremely long, extremely expensive. And I can tell you that in North and South Carolina, that's not necessarily the case. For the most part, probate process in North and South Carolina can wrap up in about a year or less. And unless we have some really crazy situations, or someone is contesting your will, or there are people bickering, it can be a pretty simple process. How expensive it is generally is going to depend on how much assets you have. But again, it's not ridiculously expensive. However, It does mean that there may be a length of time before your loved ones can access your assets. And it can also mean that you're not necessarily able to dictate how these assets are used after you're gone. So, to the extent that you want to exercise some level of control, you want to kind of rule beyond the grave, or you want to say, I don't want my child to get any of my hard earned income until they're 30 or 40, then a trust would be appropriate and could help you avoid probate. That, again, we're just talking about a revocable trust. Now, the other flavor is an irrevocable trust. This is the option that I described where you place all of your items in a treasure chest and you relinquish the keys to a different person. That is definitely not the appropriate thing for everyone. It is a pretty restrictive form of planning, but it can have lots and lots of benefits, especially if we're talking about wealth management and long-term care planning. So in the case of an irrevocable trust, you can still have some of the same benefits that I mentioned before. You can, of course, dictate how you want the assets to be distributed and to whom, who you ultimately want to receive it and when, but you lose control over these assets. Unlike the revocable trust, where the key is in your hand and you're able to decide what things go in and when they go out, in an irrevocable trust where you've relinquished control, once you transfer those assets, it's as if you've given them away. And the individuals that you've selected to be your lifetime beneficiaries, they are ultimately the ones in control. So this type of planning is appropriate for someone who wants to do some type of asset protection. Maybe they say, I have a couple $100,000. I know for a fact I don't want to use all of it on nursing home or other types of expenses that may come up. I know for a fact that I want this chunk of money or these assets to go to my children or to go to these individuals. That person who makes that decision is okay at that point with completely relinquishing control and having nothing to do with that asset from that point forward. In so doing, after a certain period of time, this asset may no longer count against them, and it may allow them to qualify for other benefits down the road, such as Medicaid or VA benefits, if the assets are high enough that it would make them ineligible. I don't want to go too far in the weeds on this because we can have a completely separate webinar about long-term care planning and irrevocable trusts. But all you need to remember here is that there are two different types, revocable and irrevocable. The first type allows you to maintain control and certainly allows you to avoid probate. The second type is more appropriate for long-term care, for special needs, for asset protection, and certainly means you do not have control, very little control, after you've relinquished or transferred those assets to that type of trust. Touched a little bit on probate. Again, the probate process in our two states is not overwhelming, but it can be a pretty long process. So if you have minor children, or if you have disabled children, or if there's a need for whatever reason for individuals to have access to your assets immediately, or at least sooner than, let's say, 9 months, then probate may not necessarily be ideal. All right. So what exactly are we wanting to consider? And I'm actually going to stop the presentation and kind of free flow from here. But what exactly do you want to consider when you are doing your estate plan? When I sit there and I talk to my clients about estate planning, I really want to get all up in their business. I have heard people mention a couple of times that estate planning is pretty much just you putting your wishes on paper. But it's important to know that it's so much more than that. It's not just about putting things in black and white. Anyone could pull documents online. It's really about having the whole picture in front of you. What exactly do you want to happen at the end of the day? Are you the type of person who really don't care much about what happens at the end? Do you just want your assets to go to whoever and you're like, well, I'll be gone anyway, so they can do with it whatever they want? If that's the case, then your estate plan may be relatively simple and you may not have to worry about much. In fact, there are actually state laws in place, and they're pretty similar in both of our states, where your next of kin, specifically your spouse and your children, if you had absolutely no estate plan, they would get your assets through the probate process. So if you did absolutely nothing, that would automatically happen. But if you have specific wishes, if you have individuals that you never would want to touch your assets at all, if you have minor children, for example, and let's say you're in a second marriage and you never want the ex-spouse or that child's other parent to have access to those assets or control of those assets. If you are the type of person who feels like I've worked hard and I do not want to be in a position where I'm spending $10,000, $15,000 a month on nursing home care and leaving nothing for my loved ones, then the type of planning you're going to want to do is going to be a little bit more sophisticated. So Melissa touched a little bit on Medicare and Medicaid and long-term care planning, but I want to kind of go a little bit deeper on some of that. When we're thinking about your wealth, ultimately the idea is not just to have it while you're here and leave nothing. At least that's not my specific goal. I would think that you would want your wealth to follow you, to be able to kind of make a difference for the people that you leave behind, even if it's not people that you care about. Maybe there's an organization that you care about. You want to make sure that that wealth kind of sticks around. It would kind of stink, honestly, if you worked for 30 or 40 years, you saved a couple $100,000, you didn't even get to travel or use it or enjoy it. And in a matter of 2 to 3 years, you spent all of it just on having a caregiver come into your home or in going to a nursing facility. When we think about the programs that are available for individuals or to help them pay for these types of services that they may require at this stage in their life, honestly, they don't really exist. Unless you are a veteran, there are really no other programs that will help pay for long-term care. And that is the biggest thing that can help dwindle your wealth very quickly. You can do all these other things with Melissa. You can have these insurance policies in place. You can have wonderful investments. You could have a beautiful portfolio. But if something happens where your loved ones aren't able to provide care for you at home and you're having to waste, I don't want to say waste, but you're having to use all of that in a very short time span, it almost seems like it's not worth it. There are other types of planning that you can do that could allow you to qualify for the only other program that would provide assistance with long-term care, and that is Medicaid. Medicare, which she talked about briefly, is not a program that will pay for nursing home or long-term care needs. A lot of people seem to think that that will be the case because you've paid into it for so long. And as she mentioned, there are definitely a lot of services that are covered, such as services that you may need, like wheelchairs and rehabilitation services. But when you are in a position where you need skilled care, you have to have someone help you with a few or more of your activities of daily living. You can't stand on your own. You need someone to change your bedding, to feed you, to bathe you, and do some of these other things for you. You're not in a position sometimes where you can stay at home, and you're probably not in a position where you could stay in an assisted living facility. A long-term care facility can receive assistance from a program like Medicaid, but they not only require you to be sick, but you also have to be completely broke. You may think that you're already broke, but honestly, if you have some real estate, you have a couple of vehicles, you have some money in the bank. Really, if you have more than $2,000 in assets, you technically are considered too rich to qualify for a program like Medicaid. But if you do some of the more restrictive planning that I talked about, including some of these irrevocable trusts, and there are other things in there that there are other resources and strategies that can be utilized as well, that can ultimately help you qualify for long-term care services, which makes a difference because instead of having to dig for $10,000 or $15,000 out of your pocket to pay for such care, you might be able to get that assistance through a program like Medicaid and save these things for your loved ones. So I want to check in the chat real quick. I kind of feel like I've been rambling for a bit, just to check in to see if anyone has any questions. So just to recap real quick, estate planning, certainly not for the super rich. Estate planning is the type of planning that's necessary so that you can ensure that your wishes are protected not only after your death, but also during your lifetime. Estate planning includes appointing individuals that you trust to make certain decisions for you. And as it relates to wealth management, estate planning can be extremely important in preserving your assets and making sure that you're able to qualify for other programs such as Medicaid and VA benefits so that you're not having to use all of those assets to pay for care. So that is it in a nutshell without me going into too much detail. What, if any, questions do we have, Kiana?
So I'm not seeing any questions in the chat box, but we do have a raised hand. Let's see.
Hi, Carlita.
Hello. If we want to contact you, is your contact information available?
It is available, and I actually think I stopped right before we got to that screen on my PowerPoint, but I will definitely make sure to include that information in the chat.
Okay, great. Thank you.
Sure thing.
Okay, do we have any other questions? And at this time, you don't have to use the chat box. You can actually just raise your hand if you'd like. Carmelita, do you have another question?
Oh, yes, I'm sorry. Didn't know it was showing. Okay, let's say you don't qualify for Medicaid and the other options may not work for you either. You know, you're sort of like on the line or, you know, on the fence. I guess, how do you handle that?
Elaborate for me a little bit, Carmelita, when you say you're on the fence.
Meaning you may have too much, although not a lot, over the guidelines for Medicaid. And the other one, the irrevocable, what was it? Trust. Or am I confusing the two? The irrevocable trust and the revocable trust. Were those the options regarding long-term planning, or were they options associated with something else?
Great question. So when we're talking about long-term care planning and specifically with Medicaid, let's completely take the revocable trust out of it. The idea here when we're talking about the irrevocable trust and these other types of strategies is to essentially convert your assets from countable to non-countable. So when you talk about being on the line, I think I kind of understand what you're trying to say, which is really the situation that a lot of people find themselves in. They have just enough to be ineligible, but not nearly enough to actually qualify. So they may have a couple $1,000s a month in income and maybe say $20,000 or $30,000 in assets. The $20,000 or $30,000 may make them ineligible for Medicaid, but their $3,000 a month is not nearly enough to pay for their $8,000 or $9,000 facility bill.
That's
That
exactly
situation where is that kind of what you're thinking?
that you actually said it very well.
Okay. So in situations like that, of course, we're going to be looking at your assets as well as your monthly income to figure out what's the best strategy. So she mentioned in the last session about spend down and how that was a big no-no and something that they certainly do not recommend. Certainly spending down is probably the last thing that you want to do, but that's certainly one of the strategies that you can employ to get your assets below the limit. And in some cases, if you're not proactive about planning, it may be the only choice that you have in order to qualify. The irrevocable trust piece that I talked about is really a proactive planning strategy. So for somebody who's still well, and ideally who will not need long-term care services for at least 5 years, that might be a good strategy. The reason why I say at least 5 years is because there is something called a Medicaid look-back period. That means any money you give away, whether you give it to someone in cash or transfer it into a vehicle like an irrevocable trust, gift it, whatever, that can count against you. It can cause you to have a penalty, and it can ultimately make you ineligible for those services for a period of time. The government doesn't want you to wake up one day, be sick, and say, okay, I'm going to get rid of all my assets so that I can qualify for Medicaid. So naturally, that's why some of those rules are in place. But if you're proactive and you're saying, my husband and I, we're well, I'm just kind of giving you a husband, Carmelita, I'm sorry. But as part of my story here, you're saying my significant other and I, we're doing well. We have some assets. We know we want to leave this for our family, but we do know that we have some health issues. We know that he has Parkinson's, or we know that I have dementia in my family, and that at some point down the road, we likely will need some type of long-term care services. We don't want to have to pay $120,000 a year in order to cover for our care. We want to put ourselves in a position where we could qualify for the types of programs like Medicaid that will help us pay for it. Then you come see someone like me well in advance before you actually need that type of service. And we could strategize some type of plan where we could restructure these assets. It could include a trust, depending on how much assets we're talking about. It could include other strategies that convert your assets from countable to non-countable. I keep saying from countable to non-countable because there are certain things that Medicaid look at and they'll kind of give you a pass. It won't count against you. But then there are other things that they'll look at and say, yes, this definitely counts against you, and you either need to spend it down, get rid of it, or something before you qualify. So being able to, having time is probably the biggest benefit to this type of planning. It gives us the most flexibility, and we're able to put a trust-based plan or other type of plan in place to meet your goals. A revocable trust could very well be a part of that plan, but it's important to understand that a revocable trust does not provide any type of asset protection for Medicaid or the long-term care type of planning that I'm referring to. For all purposes, for Medicaid purposes, these assets, even though they're in a separate structure, they're see-through, they're yours. They may be in a completely different name, but they're within your control. And as long as they're within your control, then they're available, and therefore you can spend them down or use them to pay for care. But if they are in a different vehicle, such as the irrevocable trust, where you've relinquished control completely and the magic time has elapsed, then it could possibly be exempt for Medicaid purposes, and you could still qualify and get that assistance. It's very, very case specific. There are lots and lots and lots of nuances. There may be strategies that are available to one family that's not available to another. For example, a married couple may have certain strategies that we can employ for them that I can't do for a single person, or an individual who has a child with special needs. There may be strategies that I could put in place for them that I couldn't do for another who just has a minor child. So it is very, very case specific. Did that answer your question?
It did. You said it
Awesome.
very well. Thank you.
Thank you, Carmelita.
We have one other question here. Okay.
Hi, William.
Yes, a quick question. Excuse me. Can you speak to any of the VA benefits that can play into estate planning?
Sure. Do you happen to be a veteran?
Yes.
Okay. So usually, if you are a veteran and you serve during wartime, of course, you've paid your dues. You can qualify for the VA to provide aid and attendance services. It's not like Medicaid. It's not as restrictive. You are allowed to have much more assets. It's definitely not at the $2,000 range, but you are still a little bit restricted. So for individuals, for example, who have, I would say, assets that are above $120,000, they may benefit from doing some type of planning to restructure their assets so that they don't risk their eligibility for aid and attendance. But if your assets are pretty not modest, or if they primarily consist of, let's say, your home, a car, and say less than $150,000, then you're probably fine and would still be able to qualify for VA for aid and attendance. The Medicaid piece is a lot more restrictive and generally requires a lot more planning.
Got it. Thank you.
You're welcome, William.
Do we have any other questions? Let's see, let me check the chat box here. Okay, not seeing anything else in the chat here. Okay, well, I guess while we give time for another question, Soraya, do you mind sharing your contact information with everyone? That way.
And actually, I do not see. Where in the world is the chat box? Okay. All right. I can be reached at 803-262-0442. My office, I feel like I'm sending this message in the chat, but I'm not sending it to everyone. So I'll repeat that again. That's 803-262-0442. My office is located in Rock Hill, but as I mentioned, I am licensed in North and South Carolina, so I can serve individuals in both states. We are located at 452 Lakeshore Parkway, Suite 120. So if you've ever been to the Social Security office in Rock Hill, we're right in that business park across from York Tech. And our website is taglegacyplanning.com. You could check us out. You could schedule an appointment. You could find out more about our services and all that good jazz.
And I actually, sorry, that message did go directly to me, so I resent it to everyone. But just to let everyone know, I will share out Soraya's information in case you all didn't get the chance to write this down. And that way, if you have any questions for her and like to set up a meeting, you're able to get in touch with them.
I do want to, if there are no other questions, I do want to leave you with a couple of pointers. there are lots of things that you can do as it relates to estate planning and wealth management that may not necessarily involve an attorney. So I want to give you some of those pointers now so that you can kind of look at them. Number one, you definitely want to make sure that your beneficiary designations are up to date. You would not believe how many people have been, divorced for many years, but their beneficiary is still their former spouse, or how many people list their minor children, for example, as beneficiaries. All of those things are things that could potentially create problems for your heirs down the road. Obviously, you don't want your ex-spouse to end up being the beneficiary. There's no rule that says that you can't leave your assets to anyone you choose. So if you happen to not change it and they end up with it, that might not be so great for you or your heirs. Minor children. Lots of times people think, well, my children are the people that I want to leave things to, so I'm just going to make them the beneficiaries of my life insurance and anything else that I get. But it's important to understand who's going to manage that. If they're a minor child, they obviously will not have the opportunity to manage it themselves. So it's either going to require some type of court intervention to appoint someone to manage it for them. That person may or may not be someone you care to have manage your assets, or you could create some type of plan where maybe your assets go into a trust and you can write the rules on who you want to manage these assets and how you want them distributed. Number two, try to avoid probate at all costs, even though I said it's pretty simple, just for the sheer purpose of not having to have your loved ones wait for many months or to have to pay creditors before they can access these assets. There are a couple of things that you can do that don't necessarily include creating a trust. Certainly, I mentioned creating a trust is one way, but you could restructure some of your accounts to ensure that they are payable right after you pass away without having to go through the probate process. For example, your bank accounts, your investment accounts, you could make those payable on death or transferable on death directly through the bank without even seeing an attorney. Most banks have their own specific forms, if you request them, where you can directly say, after I pass away, I want this account to go to this person. That way, that account doesn't even have to go through the probate process. Once you pass away, that individual can get direct access. Number three, make sure you appoint people whose views are in line with your own. Certainly, I think during COVID especially, I think it became clear that people that we sometimes thought had the same views and ideas and would make the same decisions as we would ourselves did not. You never know what controversial something may come up. And God forbid, if your default person is someone whose views aren't in line with your own, they make a decision that would be forced on you that if you could make that decision yourself, you certainly would not make. Those are definitely all things that you want to consider. When I say I get all up in the business when we're talking about doing estate planning, I mean it, because the other thing you want to consider is these people that you're appointing to be in charge of your affairs, what do their affairs look like? Do they have good credit? Are they going to misuse your funds? Are they the type of person who is going to be super emotional and therefore may not be the right person to be your healthcare agent because they're going to be crying in the hospital and won't be able to make that decision? Those are things to consider. Just because you like them, they may not be the best person. Are they the type of person who could stand up to their wife or their husband, or are they going to allow a third party to kind of control their decisions such that they're not even your agent, but someone else is making the decisions on the back end? Those are definitely all things that you want to consider. When you decide, for example, that you don't need a trust, you don't necessarily need to create specific rules, you're okay with just your son or your daughter or whoever just getting something outright, That's all well and good, but what you leave them then becomes theirs, right? Once it's out of your estate, is theirs. Do you really like their husband or their wife? If something were to happen to them, would you be okay with that person walking away with half or maybe all of your hard-earned assets? Those are all things that you should consider. And that's what I mean by looking at the bigger picture. You could put things in black and white. It can look pretty. It can have all of the words that seem like they're the right words. But if the end goal is frustrated, then your estate plan means nothing. So you definitely want to make sure that if you are working with individuals, I agree with Melissa that you want to make sure that all the professionals who are working on your wealth management, your wealth plan in general, that they're able to work together. But you also want to make sure that all of these individuals are clear on what the end goal is and that the steps that you're taking in between are going to get you there. It wouldn't make sense for me to tell a 50-year-old person who's relatively healthy that they should put all of their assets in an irrevocable trust because they may need long-term care services in the future if part of their long-term goal is to retire early and travel and have access to funds. That's not necessarily going to meet all of their long-term goals. It's just going to look at one part of it. So all of those things are things that you want to consider. Last but certainly not least, make sure you have conversations with the key people that you plan to involve in your plan. If you're going to appoint someone to be the executor or the personal representative of your estate, make sure you explain that to them and what that ultimately will mean. Make sure you have conversations with your heirs so that they understand that the person you put in charge, quote unquote, is there to act in their best interest and that you've outlined everything that's supposed to happen. Make sure the person that you've appointed to be your healthcare agent or your power of attorney clearly understands what your healthcare wishes are. Don't just give them blank powers and say you can make medical decisions for me. If you have specific requests, for example, if your faith doesn't allow you to get blood transfusions and you want to make sure that your healthcare agent doesn't make such a decision, those are all conversations that you need to have. You need to make sure that your power of attorney, especially if you are an individual with special needs, is not one of the ones that you get from LegalZoom or from Office Depot, that it has enhanced powers in it that gives flexibility to the person who's going to manage your affairs so that they can do more sophisticated planning for you. Even if right now you're well and you may not want to do anything too restrictive, maybe down the road, you may want your son or your daughter or whoever else to be able to do that more restrictive planning. And all of that can be included in a good, solid estate plan. And making sure we have all of that in place well ahead of time before you need it is really the best way of doing it. I love, love, love helping everyone at every stage, but certainly if you come to me when you're already on the hospital bed, then what I can do for you then is a lot more limited than what I could do for you now while you're well. All right. So I hope all of that, those tips are helpful, and I hope it encourages you to, at minimum, have those conversations with your people. Around the holidays, I like to tell people that's when you want to start looking at people with the side eye and really take inventory of who your next of kin are and who these default people that may end up taking care of your things, what they really are about. Because people change. So you may have in your mind that this person should, take care of your finances or your children or whatever, but you find out that they may not be suited for that. All right. So I think there may be another.
Yes, we do. I think Carmelita has another question here.
Regarding the forms to be completed, my son, I think, as far as him managing everything, 25 might be a good age. So if I want to assign that age, then is that paperwork at the bank for me to complete? Or is that something that would be written by someone like yourself in estate planning?
Okay, let me clarify real quick. When you say 25 might be a good age, are you saying 25 might be a good age for that person to be in a fiduciary capacity and manage your affairs, or to actually inherit from your estate outright and be able to take care of what they inherit from you?
The inheritance piece.
So the inheritance piece, if you want to dictate at what age or when they receive it, yes, that is definitely something that you'll want to address through an estate planning document. The form that I mentioned at the bank, the payable on death forms, transferable on death forms, they're pretty standard. You're just basically appointing a name. There's no other stipulation that you could put on that other than just making that person the beneficiary.
Now, how is it different with you going through the bank to make that person a beneficiary versus, let's say, if there was paperwork through your employer where you listed the beneficiary for certain things to go to?
It's similar, except we're probably talking about different assets here. So through your employer, maybe you have your pension, you have life insurance, you may have, some type of private whatever that your employer offers. Yeah, similar as listing individuals as beneficiary on those, doing a payable on death or transfer on death form through your bank is going to ensure that they receive it directly the same way. Certainly, you wouldn't be able to do the bank form through your employer.
Okay. And so that eliminates, again, just to clarify, that eliminates probate being involved in any question about who would get those, the funds.
That eliminates probate being involved as it relates to those assets. So if you're someone, for example, who has no real property, you have no other assets that would need to be probated, and the only thing we're talking about are life insurance policies and bank accounts, then realistically, yeah, you could avoid probate completely just by doing those forms without even having a trust. But if you have a home, for example, if you are the sole owner of that home, then it has to go through probate to be transferred. So you won't be able to avoid probate completely. The process would still have to happen. It's just that those bank accounts would not have to go through the probate process.
Okay. Thank
The
you.
same is true with the life insurance and all the other items that you list direct beneficiaries for through your employer.
Thank you.
You're welcome.
And we actually have a question in the chat here. Mr. Mendoza asked, what's your fee per service?
Yeah, that's a very good question, and one, unfortunately, that I cannot answer. The reason being, again, is because it's really going to be very case specific. If we're just going to be doing basic planning, we're talking about one thing. If we're doing asset protection and Medicaid planning, there are multiple steps involved. So it's really going to vary. The best thing to do if you're prepared to work with someone like me is to schedule a consultation, and then we can talk in more detail about your specific goals. And during that consultation, I'd be able to tell you what the fee for that service would be.
Thank you. And let's see. Carmelita, did you have another question?
Yes, can she spell the website that she had given out earlier, please?
Sure. It's TAG Legacy, LEGACY planning, PLANNING.com, taglegacyplanning.com.
Thank you.
Sure thing.
And as I mentioned before, of course, if you weren't able to capture all of Soraya's information here, feel free to reach out to us at the office and I'd be happy to connect you with her. Okay.
All right. Sorry about my dogs if you could hear them in the background, but I guess they were saying hello and goodbye. It was wonderful interacting and chatting with all of you. And thank you so much for your attention and your time, and hope to get an opportunity to meet or possibly work with some of you in the future, and hope you are proactive about planning so that your end goals could be met.
And sorry, I know we're wrapping up here, but we actually have one other question here.
Yeah, go for it.
And so Evelyn asked, what are the fees for a consultation?
So a half-hour consultation is $150. If you, generally when I do seminars and things like this, I do offer complimentary consultations for individuals who attend the seminar. So if you mention that you were an attendee, if you reach out to the office directly and mention that you were an attendee, then you can get a complimentary 15-minute meet and greet meeting with me where we can chat about your specifics.
Okay. Thank you. And then Carmelita, is your hand just raised from earlier? Did you have another question?
It's raised from earlier. Sorry about
Okay.
that.
No worries. I just wanted to make sure. Okay.
And thank you so much, Carmelita, for helping me get the words out there. I appreciate that. I appreciate all your questions.
Absolutely.
All right. Well, we will go ahead and wrap up for the evening. So thank you so much, Soraya, for being here and sharing all of this lovely information. Hopefully everyone here today has at least one takeaway. As I mentioned before, the session was recorded, so if you missed anything, it will be available on YouTube later, just for you to review and get anything you might have missed. Of course, if you didn't get Soraya's information, feel free to reach out to us at the office and I can connect you with her. But other than that, thank you all for joining us today. And I hope to see you at one of our programs soon.
Thank you all. Have a great evening.